What happens if one party to a contract begins to doubt that the other will fulfill its part of the bargain? When a promisee fears that a promisor won't keep its end of the deal, the Uniform Commercial Code, or UCC, provides a potential remedy. But in Buy Low Oil versus ParTech, a promisee with cold feet learned not to start down that path without good reason. Buy Low Oil bought software from ParTech. Under the parties' contract, ParTech agreed to service those programs for a fixed monthly fee. This ongoing service obligation required ParTech to make any updates necessary for the software to continue functioning normally in the year 2000, referred to as making the software Y2K compliant. On January 7, 1998, Buy Low wrote to ParTech requesting a written response explaining how ParTech would ensure that the software would be Y2K compliant. ParTech responded by letter on January 30, 1998, stating that ParTech was collecting data to assess whether updates were needed and would inform Buy Low as soon as a decision was made. By June of 1998, Buy Low hadn't received the assurances it wanted from ParTech. Fearful it might be running out of time, Buy Low invested in an entirely new computer system, including both software and hardware. In November of 1998, ParTech wrote to Buy Low stating that ParTech would supply new software to make Buy Low's system Y2K compliant free of charge, and that the software needed to be installed before January 1, 1999. On December 18, 1998, ParTech sent the necessary software with detailed installation instructions. Buy Low never installed the software because by then it was operating on its new system. Buy Low sued ParTech for breach of contract in Michigan State Court, characterizing ParTech's conduct as a repudiation of the contract under the UCC and arguing that it therefore had a right to purchase the new computer system. ParTech removed the case to the United States District Court for the Eastern District of Michigan on the basis of diversity and moved for summary judgment. ParTech asserted that it never communicated an intent to repudiate the contract and that Buy Low didn't have reasonable grounds to request assurance of performance. ParTech also maintained that it gave adequate assurance if assurance was necessary. The district court granted summary judgment for ParTech. Buy Low appealed to the Sixth Circuit.